from supplementary list for hearing on Order 41 Rule 11 Item 2. Second appeal 442 of 2003.
Yesterday we have sent an email requesting for adjournment in view of the fact that recently we have filed a wakalatnama on behalf of the appellant. So as per the senior instruction, we need some time to go through the reports.
We will not give you adjournment in 2003. We will not give you adjournment. From 2003, this case is pending.
Recently we have
Your wakalatnama may be recent, but that is not an excuse for adjournment. We don't bother about it.
Password karte jab and arrange from the senior.
You have filed an idea that you should not be dispossessed.
Yes, ma'am.
Very good. I will not adjourn it. I will reject this idea. If I adjourn, I reject it. You call your senior, whosoever you may. Call him. We are not going to adjourn this case. 2003, the matter is pending for stating substantial question of law. कितना साल हो गया? How many years? How many years?
More than 20 years.
22 years, to be precise. Yes, I am not going to attend this case. You might have filed your wakalatnama recently. We don't bother about it.
So one of the respondents have also died. He was substituted in this CMP proceedings. So, yeah. It was dismissed for default and then it came through.
You just keep pending the case. You have filed a substitute.
Just one account. Even if it is taken up on Monday, we'll file a substitution by then. In the CMP, the respondent number 4 was substituted. So we have to file a substitution.
Who appeared for respond number 4? In CNP? Is the CNP a connected defendant? It has been deleted. Deleted by the order dated signature Abhay Kumar Mehta and Manju Devi, right? Who has filed wakalatnama?
Vishnu Prabhakar Pathak.
The interference.
These ones, his name is showing in the order sheet.
Vishnu Prabhakar Pathak had appeared on behalf of OP number 6. What about OP number 4?
Oh, OP number 4 was substituted matters because in the subsequent orders, notices have also been said to be received by the substituted legal heirs.
There is death certificate here. She expired on 12/12/2019.
Yes.
Death certificate is there in the record.
So after dismiss, a second appeal was dismissed, and then thereafter it failed. Give us one opportunity to inspect the entire record and take necessary steps.
Is it an admitted second appeal? That is why the order for. Okay. So then. Essay number 442 of 2003. Counsel for the appellant has submitted that. The respondent number 4, namely Manju Devi. Manju Devi is not a party to this. Okay, 1-4, she was substituted. Respondent number 1 with bracket Roman 4. Bracket close, Manju Devi has expired on, I've given you the date now. On 12/12/2019. A death certificate was placed on record in CMP number, was found in the records of CMP number
812 of 2020.
812 of 2020. He submits that the second appeal stood dismissed for non-prosecution and has been restored by order dated 29/8/2025. And he seeks adjournment. Apparently, the proceeding against respondent number 1 with bracket 4 has abandoned. However, since the petitioner appellant is seeking adjournment, at his request, post this case on Monday. चार महीना तो आपको रेस्टोर हुए भी होगा, राइट? उसके बाद years, and you were there in the restoration. It is not something which has come to you for the first time.
The second appeal we have filed wakalatnama in November. So after restoration, we will not give the NOC for the second appeal.
No, when we talk about latches, we talk about the latches of the litigant, not your latches. I think her legal years are already on record. What is? She's only to be deleted.
We just wanted to verify.
दिखाई चलेगा.
Legal as must not be on record because it is CMP will be a substitute.
CMP में क्या क्या है?
For hearing under 41 to 11 item 15 second appeal 262 of 2008.
In this case also, Lord, they having the same fate. What happened, Lord, Mr. Bhumik, the senior advocate, was appearing. In this case, it has been transferred, but in the meantime, it was dismissed for default. CMP occupied some more time, and then CMP was ultimately allowed in between. During the pendency of the CMP, the sole appellant died. So therefore, Lord, the CMP filed by the sole appellant was to substitute, the sole appellant was substituted in CMP, and his widow and 2 sons were substituted. Now, Lord, after restoration, this has been listed, Lord.
It has been restored on 15/3/24.
Yes.
What were you doing since then?
15th March 2024. The widow is aged about 82 years now.
When
80
did she
years.
die?
Lord,
When did the appellant die?
appellant died, Lord, in 2019 during the pendency of the
इसका CMP दिखाइए.
CMP. Yes, you can see the substitution petition was filed in 2022 in CMP. Divas Wala Karan, and then Lord, her 2 sons, Siladit Karan and Bapadit Karan, they were substituted. Death certificate is annexed 1 to the IE on 3/5/2019, and that was allowed in CMP. And after restoration, no step could be taken.
What's the name of appellant?
Appellant, Lord, Sutirtha Karan,
He expired.
he expired.
But in CMP there is no substitution.
There was a substitution. Sutirtha Karan was the appellant,
He has not been substituted.
but he has died. I know. Lord.
So this substitution, what is the consequence?
Then Lord, we have to take a step. Lord. I think
No step. In second appeal में क्या step होगा?
Second,
जब आप restoration में उसमें substitution नहीं कराए, the matter has been restored without substitution.
that was not indicted in 2022 during the pendency of the
That's right.
restoration.
That's right.
This is a fact not which I have been informed. So I will take not step setting aside abatement and all this.
अभी कैसे setting aside abatement? अभी तो restoration ही गलत हो गया.
The restoration,
You see, if you get a petition restored without taking steps in the restoration application,
then the appellant will not who filed the restoration petition. The appellant continued with the CMP. Thereafter, Lord, I could know, Lord, that
the restoration petition itself has abated on account of non-substitution.
that was not ultimately not it was restored.
Restoration का ही order को recall करना.
Restoration is not defective.
It is defective because He expired during the pendency of restoration
Restoration,
application,
yes.
and we have got it restored without substitution. So that
Of course, after
consequence has to be
restoration, I could get the information. That is the reason it is my duty to point out. So I have informed, as I have been informed, that I, as a lawyer, I should inform about this fact. Because we were not aware about the fact that he died. That is the reason. But after restoration, when we intimated this fact, then we could gather this information that he is to be restored, he is to be substituted. Or otherwise, I am
essay number 262 of 2008. The learned counsel for the appellant has submitted that the sole appellant has expired in the year 2019.
2022. We had the information after restoration.
In the year 2022. He submits that this second appeal was dismissed for default. On 3/1/2018.
2018.
And thereafter CMP number 222 of 2018 was filed seeking restoration of the second appeal. And during the pendency of the restoration application, the sole appellant, who was the petitioner in CMP, expired. However, apparently this fact was not brought to the notice of the court, and no petition for substitution was filed on CMP number 222 of 2018, and the second appeal was restored by order dated 15th of March 2024. Counsel for the appellant seeks adjournment. Monday,
Only 1 week. So that
2008 तक के सभी टाइम ही अटेंड कर सकते हैं, औरों के मरने का वेट नहीं करना।
Monday.
आपको जो मन हो करें। The order of restoration itself is a nullity.
Of course, not. You can say dead person. Of course, then I can't wriggle out from this position. But the
Yes,
fact
sir.
remains not this.
इसको डिस्कस करने के अलावा मेरे पास कोई उपाय नहीं है।
I can file a proper application.
किसमें?
Because
पहले तो
after
restoration nullity है। पहले तो restoration का order recall करके आपको हम नहीं ऐसे permit करते।
because not this restoration matter, the appellant will not appellant in the second appeal, who was the petitioner in the restoration application, who died not during the pendency of this case.
It's a
Now
nullity.
this fact was not known to
I
me.
appreciate you had naturally you might not be knowing it.
Otherwise steps could have been taken.
Yes, yes.
Otherwise steps could have been taken. One week time, if possible.
Delay भी कंट्रोल नहीं हुआ. आपका petition was barred by limitation.
Yes,
There is no order condemnation of delay also.
of course. It was restored.
It was just.
Yes.
It also appears from the records of CMP number 222 of 2018 that the petition for condemnation of delay in filing the petition for restoration being IE number 4199 of 2018 was filed seeking condonation of delay of 95 days.
It was quite around in the CMP.
Yes. The order of restoration was passed without notice to the respondents, without condonation of delay, and without substituting the sole petitioner. अब आप मंडे को जो मर्जी करें, क्या मैटर है, इतना क्या सीरियस है?
कुछ नहीं है, substitution, only one substantial point of law is involved, that is annex A. The fact is that the sole appellant was a teacher and come joint secretary of this Bengali society.
कुछ नहीं है सर आपके केस में, मेरिट में कुछ नहीं।
मेरिट में है, मेरिट में वो जो एक्ट का वायलेशन है,
कुछ
जैसे लॉर्डशिप सी।
सर ये जमीन का डिस्प्यूट नहीं है।
नहीं, जमीन का डिस्प्यूट, टीचर थे,
टीचर का
इनको टर्मिनेशन कर दिए विदाउट एनी जुरिस्डिक्शन एंड इन व्यू ऑफ द बार प्लेस्ड अंडर द बिहार सेकेंडरी स्कूल एग्जामिनेशन स्कूल एक्ट, दैट इज द ओनली सोल पॉइंट व्हिच इज
नहीं
इन्वॉल्व
है सर, इसमें कुछ नहीं है।
बिकॉज़ द
बस अब आप मंडे को जो मर्जी होगा।
मंडे को
आफ्टर वेकेशन नहीं करते।
इन दिन में कॉन्टैक्ट ही नहीं, उसका फोन नंबर भी खत्म हो गया।
अच्छी बात है, हम इसमें कुछ भी नहीं करेंगे, बस मंडे को डिस्कस करते हैं। बोलिए अभी कर दें।
तो मेरिट में सुन लीजिए,
हम
मेरिट में सुन लीजिए,
कैसे सुनेंगे? मेरिट में नहीं सुनेंगे।
यही एक प्रॉब्लम मेरे साथ है।
हम मेरिट में नहीं सुनेंगे सर, आपका रेस्टोरेशन ही गलत है।
रेस्टोरेशन गलत है,
बस बात खत्म।
रेस्टोरेशन
Restoration is a nullity.
नंबर
Should I hold it?
then I have to make a prayer for recall of the
हम नहीं जानते आपको
restoration
जो
application.
वो हम नहीं जानते आपको क्या।
That step I have to take them for which some time more time is required.
सर ये डेड केस में क्यों होता है?
डेट के जो मेरिट में डिसमिस हो जाए तो कोई बात नहीं।
कुछ है ही नहीं इस केस में। आपको
इसमें-
क्या लगता है आपका लिटिगेंट आपके पास आएगा? रेस्टोरेशन के बाद आपसे पूछा है?
वही एक ही इंफॉर्मेशन हम जब आदमी के थ्रू खबर कराए तो एक ही इंफॉर्मेशन मिली और उसके बाद हम रिक्वेस्ट के नहीं आए तो
नहीं आएगा।
ये जो एक ही लॉ पॉइंट है, ओनली वन एंड दैट इज परफेक्ट लॉ पॉइंट।
लो पॉइंट आपका इस टेक्निकल रीजन के कारण लॉ पॉइंट सुन नहीं।
टेक्निकलिटीज अलग तो हम समझ लें।
सिविल लॉ में आपको पता है जहाँ लिमिटेशन होगा, आप तो रेस्टोरेशन में अपीयर भी नहीं हो रहे, आपके एब्सेंस में ऑर्डर होगा।
अपीयर होते तो लिमिटेशन प्रेस ही कर देते।
हाँ वही ना, तो आपको तो उस ऑर्डर को रिकॉल कराना चाहिए।
इसीलिए कह रहे कि रिकॉल करने के लिए हमको एक हफ्ता का टाइम दिया जाए, डू ऑल नीडफुल फॉर द सैटिस्फैक्शन ऑफ द एटलीस्ट डेड पर्सन। आई कैन डिस्चार्ज माय लीगल ड्यूटीज।
ट्यूसडे को कर देते हैं बस लास्ट, वो सब ट्यूसडे सप्लीमेंट्री बात।
I have to take a step in the restoration fast.
उनको होगा ना तो वो आपके पास दौड़ के आएंगे। देखते हैं।
Then petition to this
Item
समझ
16.
आएगा।
कोई बात नहीं, आप बोलिए ना कि हम उसका रिकॉल के लिए फाइल किए, तब हम आपको टाइम दे देंगे,
ठीक,
क्योंकि वो तो गलत हो गया।
हम ऑर्डर भी नॉन अफेयर्स, अगर हम
उसका आप
दस
रिकॉल के लिए फाइल करें।
हम अगर अपियर करते तो हम पॉइंट आउट करते कि 95 डेज डिले आईए वाज देयर,
अब मर भी गया,
वहाँ फॉल्ट हम नहीं है, हम तो आईए दिए हैं।
कोई बात
Item 16, second appeal 137 of 2009.
इसमें ऑर्डर 23 रूल 3 में फाइल की हम कंप्रोमाइज फाइल की, बहुत पार्टी है ज्वाइंट फाइल।
बताइए क्या है
नंबर-
आपका टर्म्स ऑफ कॉम्प्रोमाइज? सब लोग हैं इसमें?
हाँ सब लोग।
कहाँ है आपका टर्म्स ऑफ कॉम्प्रोमाइज?
IA नंबर 14380 इसके पारा में ही हम लिखे हैं पारा 4 में कि इक्वली डिवाइड कर लिए हैं दोनों शेयर टोटल 32 डिसमिल जमीन है और एक पंचायती हुआ था जिसका फोटोकॉपी है ओरिजिनल नहीं है उसका हम अनेक्चर करना है उसी के बेसिस पर दोनों में कंप्रोमाइज हुआ है दोनों पार्टी का एफिडेविट
तो इसको सिर्फ इन टर्म्स ऑफ कॉम्प्रोमाइज
यस यस
आपको सबकी तरफ से हैं
तो आपकी तरफ से है बाबूलाल और सुमित्रा देवी
और बाकी
बस
तो
वही
ही
IA number 14380 of 2025 in second appeal number 137 of 2009. The learned counsel for the parties are present. This appeal has been filed against the judgment and decree dated 4/4/2009 within bracket decree signed on 24/4/2009 bracket close passed by the district Judge Kodarma in title appeal number 17 of 2008, whereby the appeal has been allowed and the judgment and decree dated 15/3/2008 within bracket decree signed on 29/3/2008 passed by the Munshi Kodarma in title suit number 11 of 2000 dismissing the suit has been reversed. The suit was dismissed, the appeal was allowed. Consequently, the defendants are the appellants. The learned counsels have jointly submitted that the matter has been settled out of court and a joint compromise petition has been filed through the aforesaid interlocutory application. They submit that the terms of compromise be recorded and the appeal be disposed of in terms of the compromise. They have referred to paragraph number
4
4 5 6
paragraph 4, 5
6
and 7 of the interlocutory application, which reads as under. Considering the submissions, this appeal is disposed of in terms of the compromise. Office to prepare the decree accordingly. In terms of the aforesaid compromise, वो same report हो जाएगा.
Item 17, second appeal 560 of 2015.
Yes, appellant. Rejected.
क्योंकि मेरे को तो आपने कल पहले डिसमिस फॉर डिफॉल्ट हो गया था उसके बाद इसको रिस्टोर कराया तो 2 साल तक उसी तरह पड़ा रहा बार बार रिमाइंडर देते देते तब अभी पिछले
अब आ गया ना केस अब
हाँ
कैसे
yes, लेकिन आई एम नॉट रेडी बस यही प्रॉब्लम है
Why
रात
are you not ready?
9 बजे रात में हम जूनियर फोन की थी आपका केस लगा
तो फाइल तो मिल जाएगा ना आपको
हाँ फाइल है
फाइल खोलिए फाइल खोलिए
फाइल तो मैं लाई नहीं हूँ मुझे भी एक डेट ले लेके अच्छा से तैयारी करके
कोई बात नहीं फाइल नहीं लाए तो कॉस्ट कीजिए
फाइल नीचे होगा हो सकता है मैं लेके आ रही हूँ थोड़ा सा एक दो और
इसको जरा फर्स्ट आपने कोड का रिकॉर्ड दीजिए सच इसमें तो रिकॉर्ड नहीं होगा हम पास ओवर कर रहे हैं नीचे आपका फाइल आया होगा आप आ जाइए 15 मिनट
Yes.
3:15 बजे आपको केस को करेंगे
Item 18, second appeal 123 of 2018.
यस
पेंडेंसी ऑफ दिस अपील में और 3 अपीलेंट इस प्रेजेंट करेंगे
कब
डेट तो नहीं सो बताए हैं लोग लेकिन 25 में
आप ये किस तरह का सबमिशन
नहीं क्योंकि हम
डेट नहीं पता है
नहीं पूछे
इसीलिए वो चीज को क्योंकि हमको डेट नहीं पता इसलिए हम वो चीज
तो आपको पूछना चाहिए ना, आपको कोई बोल रहा है कि मर गए हैं तो साल सदी कुछ तो पता करना चाहिए कि 19 सेंचुरी
25 में 25 में
25 में कौन कौन बने।
आपको अपलेंट नंबर 1
इसका रेस्टोरेशन एप्लीकेशन,
फिर अपलेट नंबर 7 और अपलेट नंबर 8।
रेस्टोरेशन के पहले बने के बाद बने।
रेस्टोरेशन फाइल करने से
फाइल नहीं, ऑर्डर
ऑर्डर से पहले
ऑर्डर से पहले मरे है ना, ऑर्डर से पहले मरे हैं तो आपका रेस्टोरेशन खत्म।
क्योंकि वो चीज हम
बहुत सीरियस बात है, आप रेस्टोरेशन के समय आप लोग ध्यान नहीं देते, किसी तरह से रेस्टोर हो जाए, नोटिस हो चाहे नहीं हो, कुछ हो चाहे नहीं हो, बस रेस्टोर हो जाना चाहिए। क्लाइंट को खबर भी नहीं रहता है कि रेस्टोरेशन फाइल हुआ है, क्योंकि वकालतनामा तो लगता नहीं है रेस्टोरेशन।
नहीं, क्लाइंट को खबर है मैडम, क्लाइंट
होगा ही, एफिडेविट किया होगा।
इसीलिए वो चीज को तो कहना
नहीं, कभी-कभी ऑफिस क्लर्क फाइल कर देता है, हम
नहीं,
बहुत सारे रेस्टोरेशन ऐसा भी है।
वो चीज नहीं साइन क्यों हुआ है, इसीलिए वो चीज को तो अभी खास तौर पे अभी जो हम लोग का ये चल रहा है उसमें ये कहना मुश्किल है।
अच्छा, आजकल नहीं होता है।
नहीं, क्योंकि यहाँ के एफिडेविट करना पड़ता है।
इसको हम लगा दे रहे हैं परसों। अपीलेंट है ना, अब उसको तो बुलाने में आपको कोई दिक्कत ही नहीं।
नहीं, बुलाने में हम लोग को प्रॉब्लम भी होता है ना, डायरेक्ट हम लोग नहीं रहते। अब उसके आगे बीच वाला रास्ता हम डैश करते रहे इसलिए। हाँ, ये हम कह सकते हैं कि प्रीएम्प्टरी ऑर्डर कर दें और जनवरी में कोई डेट रहेगा, कोई
क्या प्रीएम्प्टरी ऑर्डर करेंगे?
कि अगर हम
उससे
सब्स्टिट्यूशन
क्या होगा? फिर से रेस्टोरेशन वो सब करेंगे ही नहीं। अगर आपका सब्स्टिट्यूशन किसी डेड आदमी को रख के हुआ है, इसी ग्राउंड पर रिजेक्ट करना, इससे कुछ जरूरत ही नहीं है आपको बोलने का इसके बियॉन्ड।
ओपनिंग डे में ही रख दिए हम लोग, जनवरी में खुलते खुलते।
ओपनिंग डे मंडे के बाद ट्यूसडे।
नहीं, ओपनिंग डे मतलब वैकेशन के बाद।
वेकेशन के बाद नहीं होगा, इतना पुराना पुराना केस करके हम लोग यहाँ बैठे हुए हैं।
18 का हम लोग कोई ज्यादा
पुराना नहीं है, 8-10 साल हो जाना चाहिए इसको।
लेकिन
ऐसा नहीं, हम ट्यूसडे को रख दे रहे हैं, हम नहीं जानते। ट्यूसडे
क्योंकि हम
छुट्टी
लोग
पे जा रहे हैं।
नहीं, हम नहीं छुट्टी पे जा रहे, लेकिन हम लोग वही बताने में तो इसीलिए हम चाह रहे हैं। आप 5 को 6 को
नहीं होगा, आपने डेट ऑफ डेथ भी नहीं बताया।
हम जो चीज नहीं, हम इसीलिए उस चीज को सबमिशन नहीं कर सकते, क्योंकि हम लोग भाया मीडिया ही
इतना लंबा टाइम आपको नहीं दिया।
टाइम के बीच में छुट्टी हो गया मेरा, तो
कोई बात नहीं,
हम लोग खुद बोलते हैं 28-29
ऐसे नंबर 128 Council for the appellant has submitted that appellant number 178 had expired in the year 2025. From the records, it appears that the case was dismissed for default. And the petition for restoration was filed being CNP number 62 of 2020, which has been restored by the order dated, and the second appeal has been restored by the order dated 21/3/2025. Upon a query of this court, the learned counsel for the appellant is not in a position to give the date of death of appellant number 178 and is not in a position to answer the query of this court as to whether the appellant number 178 had expired prior to 21/3/2025 or thereafter. The learned counsel seeks adjournment. Post on Tuesday in the supplementary process.
Item 19, second appeal 8 of 2019.
Appellant.
This also there was a death, but substitution was allowed in second appellate stage. It's both appellant as well as respondent. But probably this order is 26/7/2023. Corresponding, the registry was directed to make necessary changes in the cost title. I'm not, because their name is still reflected in the, but this order is already there. Now, this is against concurrent finding. I am the original defendant.
Just one. SN number 8 of 2019, the learned counsel for the appellant has submitted that both the appellant and the respondent expired during the pendency of this appeal, and their substitution has been allowed by the order dated 26/7/2023, and the registry was directed to carry out the necessary correction in the cost title. But
हो गया तब ठीक है नहीं
Look that side.
बिकॉज नहीं केस स्टेटस में हाँ ठीक है
let's come to the substantive.
I am the original defendant, appellant. Please, suit property, if your lordship would kindly see suit property. That suit property is 2 katthas. This is relevant. 2 katthas, 1/4 dhur. 1/4 dhur. The total area which the plaintiff claimed was she had purchased 5 katthas. Out of that, 2 katthas in the dispute, which she says that I have the sole appellant she had encroached. This was the dispute.
This 5 kattha must be in some scheduling. There is only one schedule,
Only one schedule. Only one.
which is the 2 katthas, 1/4 dhur.
Yes, yes.
Said to have been encroached by the sole defendant.
Was not encroached because the common vendor was the same. He first, it is in 66, 5 kattha was sold to us. It is not in dispute. We cannot dispute.
66.
66.
6 out of total 66.
No, no, it's 1966. 1966. The total area is which initially belonged to Nirodha Sundari Devi, but that is not in dispute. She had a son, namely Anil Kumar Chatterjee, and both parties are claiming through Anil Kumar Chatterjee on the basis of sale made by him. This is the crux of the dispute. Anil
They
Kumar.
must be having their own respective properties.
Yes, that is the core issue involved in this. Now, Anil Kumar Chatterjee first transfers in 1966 5 kattha. In the year 1966, he transfers 5 kattha, and then
To whom?
to one Jeevan Prabha De, who is the vendor of the plaintiff. It was transferred to one Jeevan Prabha De, and then Jeevan Prabha De executed another deed in favor of the plaintiff in the year 1972. Same 5 kattha.
With specific boundary.
Yes, this boundary is
Followed by mutation.
This also is there. Yes. This is also
Followed by mutation.
followed by mutation.
Okay.
Then the same property is transferred to the plaintiff. Now, your lordship will kindly take note of the total area is 19 katta 16 dhur. This was the total area.
Yes.
Now, same Anil Kumar Chatterjee transfers me in the year 1968, transfers 10 kattas, 11 and a half dhur, then he executes another deed in the year 1975, which was for 4 katta, 12 dhur. Now all these
With all
calculations.
specific boundary?
Yes. Now what the.
Just a moment.
Yes.
Followed by mutation?
Followed by mutation.
Plaintiff must be in the
Dispute
boundary.
is
Plaintiff must be in the boundary.
There is a common Pagan area which is lying, and that is the portion of dispute. Absolutely open portion lying in between, that is the portion of dispute. Now, total dispute is in the calculation itself. As to, because Anil Kumar Chatterjee had 19 katta 16 dhur, these facts are not in dispute. And he transfers 5 kattas, although our contention before the court below was that it was in Rohini the katta calculation is a larger area, but because the katta was not mentioned as to area of katta, therefore the katta would be a 720 square feet only. But let us assume that what was my defense. Ultimately, what the appellate court's finding is that your lordship may kindly see at page 12 of the appellate court finding. Page better. It starts from page 9, where the 4 points for determination were framed. Point for determination. क्या वादग्रस्त संपत्ति वादिनी जीवन प्रवाह डे से खरीदे गए संपत्ति का अंश है? क्या वादिनी का जीवन प्रवाह डे से खरीदे गए भूमि पर अधिकार हित स्वत्व दखल प्राप्त है? क्या वादग्रस्त भूमि प्रतिवादिनी द्वारा वर्ष 1968 एवं 1975 के विक्रय विलेख के द्वारा खरीदा गया? These 3 issues are decided in the next page, page 10. And relevant is para 11 where facts have been mentioned. Para 11, same page. उभय पक्ष द्वारा प्रस्तुत मौखिक एवं दस्तावेजी साक्ष्य का अवलोकन किया, जिससे निम्नलिखित उभय पक्षों के बीच मध्य स्वीकृत है कि विवादित संपत्ति मूलतः निरोधा सुंदरी देवी द्वारा से कुल 19 कट्ठा 16 धूर खरीदा गया था। निरोधा सुंदरी देवी 1951 में मृत्यु के पश्चात उनकी एकमात्र पुत्र
ये आपका पैरा 10 से मैच नहीं करता 1991 के तो आप नीचे करें ये इंटरव्यू पेज 10
हाँ
इशू नंबर 1, 2 and 3
यस इसी में पैरा 10 से स्टार्ट हो रहा, बट जो स्टैम्प्ड एरिया इज पैरा 11.
अच्छा पैरा
देयर एडमिटेड फैक्ट हैज बीन मेंशन्ड. This is the line I was reading. इस उभय पक्षों के मध्य स्वीकृत तथ्य है कि विवादित संपत्ति मूलतः निरोधा सुंदरी देवी द्वारा सलोना टाण देवघर में रोहिणी एस्टेट से कुल 19 कट्ठा 16 धूर जमीन खरीदा गया था. निरोधा सुंदरी देवी की सन 1951 में मृत्यु के पश्चात उनके एकमात्र पुत्र एवं उत्तराधिकारी अनिल कुमार चैटर्जी द्वारा उनकी संपत्ति के दखल में आए और उन्होंने अपना नाम स्वयं में नामांतरण कराया. उपरोक्त कुल भूमि 19 कट्ठा 16 धूर में से अनिल कुमार चैटर्जी द्वारा वर्ष 1966 में विक्रय विलेख सो एंड सो के माध्यम से जीवन प्रभा डे को विक्रय किया गया। उपरोक्त सेल डीड के माध्यम से अनिल कुमार चैटर्जी द्वारा सो एंड सो के साथ विक्रय किया गया। Then another admitted fact, I'm skipping all other portion. Then para page 12 last paragraph में kindly. Rest are all discussions are point out only relevant. Last paragraph. अनिल कुमार चैटर्जी ने सबसे पहले हस्तांतरण 17/10/1966 को सेल डीड सो एंड सो में 5 कट्ठा मकान, आधा कुआं, आंगन एवं जमीन श्रीमती जीवन प्रभा डे के साथ विक्रय किया तथा इसी सेल डीड का पूरा जमीन यानी लगभग 5 कट्ठा जमीन में मकान श्रीमती जीवन प्रभा डे ने लखपति देवी वादिनी ने दिनांक 24/5/72 को सेल डीड सो एंड सो के द्वारा जीवन प्रभा डे से खरीद की, परंतु सेल डीड में नक्शा संलग्न नहीं है। लॉन्ग देवी प्रतिवादिनी ने दिनांक 17/9/68 को सेल डीड नंबर सो एंड सो के द्वारा अनिल कुमार चैटर्जी से 17 कट्ठा 11.5 धूर बगान बगीचा खरीदा। लॉन्ग देवी दूसरा सेल डीड 27/5/1975 को सेल डीड नंबर सो एंड सो के द्वारा 4 कट्ठा 12 धूर जमीन खरीदा गया। नाउ दिस इज द अंडरलाइन पोर्शन मोस्ट इंपॉर्टेंट, यानी 19 कट्ठा 16 धूर जमीन की बिक्री किया, 19 कट्ठा 23.5 धूर। That means a larger portion was sold by Anil Kumar Chatterjee. And what is that excess area is? इस प्रकार जमीन मालिक अनिल कुमार चैटर्जी ने 7.5 धूर जमीन ज्यादा केवाला किया, जो विवाद का मुख्य कारण है। Now only excess area was 7.5 dhur. This was the only excess area. And next para, your lordship would find that 20 कट्ठा का 1 धूर होता है. This is very relevant. I'll point out why I'm pointing out this. Here itself the appellate court mentions जमीन की उपरोक्त वर्णित नापी के दौरान सो के द्वारा ये किया गया। रोहिणी एस्टेट का जमीन 7.5 हाथ सो जो इतना होता है, यानी 126 वर्ग फीट बराबर 1 धूर और 20 धूर का 1 कट्ठा होता है। 20 धूर का 1 कट्ठा इज इंपॉर्टेंट। नाउ व्हाट इज द सूट प्रॉपर्टी? 2 कट्ठास 1/4 धूर। दैट मींस द टोटल इट वुड बी 40 धूर। 40 धूर plus 1/4 धूर, 40.1/4 धूर. This would be the total suit property is 40 dhur. Let us assume 40 dhur. 1/4 I am skipping. It is more than 40 dhur. Now the appellate court itself says that only overlapping portion is 7.5 dhur. So how can a decree for entire 40 dhur can be given to the plaintiff? And the appellate court says that this to the suit property, entire suit property is 2 katthas 1.5.
Overlapping is one thing.
Yes.
Whether the suit property is falling within that 5 kattha.
That is the finding. That is the finding. Strangely, that is the finding. It could not have been. And the appellate court says, and both the courts are saying, that because her deed, the plaintiff's deed was earlier in point of time, and therefore that would prevail. I also admit that. We cannot dispute the legal proposition. But only to the extent of 7.5 dhur. That is all. Not more than that. But the decree is for 2 katthas. So my area of 14 katthas which I have purchased is being reduced. I have also validly purchased by the sale deed. Next 2 lines, your
बच्चे के कायदे से उपरोक्त पूरी जमीन रोहिणी कट्ठा के अनुसार अर्थात 1 कट्ठा बराबर 2531 वर्ग फीट होता। अंत में अमीन कमिश्नर की रिपोर्ट के अनुसार सारांश यह है कि पूरा जमीन 19 कट्ठा 16 धूर है। प्रथम निबंधन केवला 17/10/1966 को 5 कट्ठा जीवन प्रभा डे जमीन मालिक अनिल कुमार चैटर्जी से खरीदी थी। जीवन प्रभा डे से श्रीमती लखपति देवी ने खरीदा। दूसरा केवला 1968 10 कट्ठा 10.5 धूर रोंग देवी ने बगल बगीचा अनिल कुमार चैटर्जी से खरीदा। उसके बाद जमीन 4 कट्ठा 4.5 धूर बचती थी, परंतु अंत में केवला 4 कट्ठा 12 धूर, जो कि उचित से 4.5 धूर अधिक है। दैट इज द ओनली एक्सेस एरिया विच ही हैड ट्रांसफर्ड। But I also must bring it to your lordship's notice that our contention was that the kattha calculation would not be 2,531 per kattha, rather it would be 720. That was the main contention over which we were trying to contest the details. And then the conclusion is at page 17, where it says उपरोक्त वर्णित तथ्यों की विवेचन पश्चात मैं इस निष्कर्ष पर पहुंचता हूं।
Just a minute. कहाँ बोल रहे हैं? कहाँ बोल रहे हैं?
वो लास्ट एकदम कंक्लूजन जो फाइंडिंग है, उपरोक्त वर्णित तथ्यों के विवेचन के पश्चात मैं इस निष्कर्ष पर पहुंचता हूं तथा यह अवधारित करता हूं कि वादग्रस्त संपत्ति वादिनी जीवन प्रभा डे द्वारा खरीदी गई संपत्ति का अंश है तथा वादिनी जीवन प्रभा डे को खरीदी गई भूमि पर अधिकार हित स्वत्व दखल प्राप्त है तथा वादग्रस्त भूमि प्रतिवादिनी द्वारा 1965 एवं 75 के विक्रय विलेख के द्वारा नहीं खरीदा गया, अतः उपरोक्त तीनों विनिश्चय सुनिश्चित किया गया।
For the learned counsel for the appellant, this appeal has been filed against the judgment in decree dated 24/9/2018, wherein that decree signed on 29/9/2018, passed by the district judge Roman by Dekar, entitled appeal number 9 of 2007, whereby the learned first appellate court had dismissed the appeal and affirmed the judgment in decree dated 27/2/2007, within bracket decree signed on 12/3/2007, passed by the sub-judge Roman 7 Dekar, entitled suit number 9 of 1998. The trial court was pleased to decree the suit, and the defendant has lost in both the courts, and consequently the defendant is the appellant before this court. The learned counsel for the appellant, by giving the factual background of the case, has submitted that total 9 kattha 16 dhur of land belonged to the recorded tenant, and her son Anil Kumar Chatterjee has sold the property had sold portion of the property to the plaintiff and portion to the defendant. He has submitted that the plaintiff claimed to have purchased 2 kattha 1/4 group.
नहीं 5 कट्ठा plaintiff claims 5 कट्ठा
Plaintiff claims to have purchased 5 kattha from the vendor, who in turn had purchased the property from Anil Kumar Chatterjee. The sale deed executed by Anil Kumar Chatterjee is of the year 1966, and the purchase by the plaintiff of the same property is of the year 1972, which was followed by mutation.
yes
He submits that Anil Kumar Chatterjee had further sold 10 kattha 11.5 group to the defendant
yes
in the year 1968 and 4 kattha 12 group to the defendant in the year 1975. He submits that the suit property was 2 kattha 1/4 group, which was equivalent to around 40 groups, and the specific case of the plaintiff was that the suit property of 2 kattha 1/4 group was part of the property purchased by the plaintiff, which was by the plaintiff in the year 1966/1972, which was to the extent of 5 kattha.
yes
The learned counsel submits that the learned court has recorded a finding that Anil Kumar Chatterjee had sold excess of 7.5 group
yes
to the defendant, and consequently the suit could not have been decreed with respect to 2 kattha 1/4 group.
yes this is
The suit could have been decreed at best only to the extent of 7.5.
yes
After hearing the learned counsel for the appellant, the aforesaid facts is with respect to sale of property is not in dispute. It is also not in dispute that, as per the finding recorded by the learned first appellate court, Anil Kumar Chatterjee had sold 7.5 groups in excess.
yes
However, this court finds that the findings recorded by the learned court does not stop at that. Rather, the report of the survey commissioner has been taken into consideration in detail, who had stated that the sale deed of the defendant dated 27/5/1975 mentioned that it was relating to 4 kattha 12 group, but upon measurement it was found only to the extent of 3 kattha 12 group, which upon physical measurement was found 1 kattha less. The learned first appellate court has recorded a finding in internal page 14 in the aforesaid finding in last paragraph of internal page 13 and further recorded finding in paragraph 14 that the defendant had actually purchased area of 14 kattha 16 dhur only. Although in her sale deed, the total area was mentioned as 15 kattha 23 dhur. And ultimately the appeal has been dismissed. In view of the findings recorded by both the courts based on materials on record, this court finds no merit in this appeal, no substantial question of law in this appeal, which is hereby dismissed. So in the rights. पासो नहीं आएंगे तो डिसमिस कर दूंगी, कॉल करिए 3:30 बजे कॉल करिए.
Paso case item 17, second appeal 560 of 2015.
Second appeal 560 of 2015. The first round the case was taken up. The counsel for the applicant. Yes, बताइए.
Can you give me one chance क्योंकि
Chance
नहीं है और already I am sick, मैं तो बीमार हूँ, 3 महीने के बाद कोर्ट आई, पढ़ रहे हैं, चक्कर आ रहा है, कम से कम हमको एक दिन का भी कल तक रख दिया जाता है, आपने हम देख लेते तो फिर कल पे रख दिया जाता हम कर बहुत से मैंने इसका जुरिडिक्शन पॉइंट पे है आफ्टर 75 इयर्स डिपेंडेंट जो है सो ब्लॉक से रसीद कटवा के सीओ ऑफिस से और उसी पर केस को इनिशिएट किया रिस्टोरेशन ऑफ लैंड बिफोर एसडीओ तो एसडीओ के यहाँ वो उनके फेवर में ऑर्डर हुआ उसके बाद वो डीसी के यहाँ गया उनके फेवर में हुआ उसके बाद वो रीट नहीं फाइल करके वो जाके सब जज के यहाँ राइट टाइटल और एडवर्स पोजीशन फाइल कर दिया तो उसमें भी इनका कंकरेंट फंडिंग हो गया दोनों जगह आ गया तब यहाँ सेकंड अपील में आया बट ऑल डॉक्यूमेंट्स इन हिज
Adverse possession. आप plaintiff है कि defendant?
प्लेंटिव
Plaintiff. So you claimed adverse possession.
हाँ एडवर्स
So your plea was that
एडवर्स पोजीशन और आप 75 इयर्स ओल्ड अभी तो हैंडेड हो गया होगा कितना दिन से लेकिन अभी भी पोजीशन प्लेंटिव का है उसी का है और वो लोग ऐसे ही रिसीट लेके और इनिशिएट करके इनको कुछ और कुछ नहीं है इसमें ऐसे में कल जो भी होगा थोड़ा पढ़ने के बताएंगे recorded tenant जो है resolution after his death the property is then returned to its landlord और ex landlord settled the land to this plaintiff. By the सीधी सादा होती नंबर
The learned counsel for the appellant has submitted that on account of personal difficulty, she is not able to argue the case today. He submits that the matter be posted tomorrow. At her request, the matter is directed to be posted tomorrow to be taken up at first case at 2:15 बजे आ जाइएगा as first case होगा.
Item 20, second appeal 34 of 2019.
So one thing before I start arguing, otherwise ready in the matter, but the point that I wanted to argue has not been included in the substantial question. Yes.
You can prove substantial without your mentioning it. Who are you?
And the plaintiff merits.
Plaintiff.
The suit was filed for declaration of right title interest. It was dismissed and the appeal was also dismissed. Plaintiff is claiming title on the basis of a registered sale deed dated 5/2/1986, which was executed by the legal heirs of the recorded tenant.
Tribal, non-tribal.
Not the defendants matters are claiming their title on the basis of a registered sale deed dated 14/12/1944, which was executed by one Ahilya Kumar. And Ahilya Kumar had purchased the property in an auction sale in the year 1941.
Whose auction sale?
Auction sale was purchased in the auction sale by the recorded tenant.
Identity of property is not in dispute.
No, the recorded tenant is also not in dispute. So I am saying that I have purchased the property through legal heirs of the recorded tenant. The defendant is saying that it was sold in an auction in 41 and thereafter transferred in 44. Now I have also filed an M form and the rent fixation.
There is finding regarding auction sale.
No, my suit has been dismissed only on the ground that the original registered sale deed was not filed in the court below. Certified copy of the same was filed. So now that is already covered by Supreme Court judgment that public record of public document is also a public document. So that is one thing. Secondly, the court has come to a finding that since from the recital of the deed, it is evident that the entire sale consideration amount in my deed was not paid. So there is also a judgment regarding that a deed cannot be cancelled once the title has passed. The deed cannot be cancelled on the basis that the consideration amount was not paid. So these are the two grounds matters.
Let's see.
Yes. So I may invite the attention of the court to internal page number 10 of the appellate court judgment, running page 20.
That should be sufficient. Appellate court judgment should be
Yes,
sufficient.
yes.
Section 34, it is barred by section 34 also.
Declaration with respect to cancellation of deed was not paid in court.
What was the suit for?
Suit was for declaration of right title interest.
And no prayer for cancellation of deed.
But I have a ground against that. The property was passed to the defendant number 1 who happened to be a minor at the time of execution of the deed. So the deed in
That also
favor
requires identification, no? Whether he was minor, major.
that came
It's not ipso facto void.
that came into light by way of the evidence of
You should have amended the thing. कुछ है नहीं है ना?
नहीं ये point
आपका बात ही सुन कर लग रहा है। But the point for determination with them. Let's see the case of the respective parties first.
Turning page to it.
Yeah.
The case of the plaintiff at the trial court in nutshell is that the lands of Khata number 76, plot number 363 and others, area 6 acre 35 decimal including 3 acre 75 decimal under plot number 363 of village Aranda under 2 was recorded in the regional survey record of right in the name of so and so, and the recorded right hold and possess the lands of Khata number 76 in their occupancy right as an exclusive owner. It is further stated that at the time of vesting of zamindari under the Bihar Land Reforms Act 1950, the said recorded tenants were found in class possession over the land of Khata number 76, and rent was fixed by rent assessment case number 51 of 1955-56, and M form was issued in their names. So this is very important because they are saying that they are claiming title on the basis of a deed executed in 44. So if the 44 deed was given effect to, the M form would not have been issued in minor. And there is also a rent fixation case 10 years later to the execution of deed that the defendants are claiming title. It is further stated that in due course of time, the recorded tenant, Ram Dhobi, Ghor Dhobi and Khasi Dhobi amicably partitioned the said land of Khata number 76 and other Khatas, and they have been separated amongst themselves in mess and property and RS plot number 363 measuring in area 3 acres 75 decimals and other of Khata number 76 of said village exclusively allotted to Ram Dhobi, son of Chakurta Dhobi. It is further stated that Ram Dhobi, Ghor Dhobi and Khasi Dhobi died one after another, leaving behind their legal heirs and successors, as mentioned in the genealogical table. Ram Dhobi died leaving behind two sons, namely Gulnath Bhetta and Sodho Bhetta. Gulnath Bhetta died leaving behind Krishna Bhetta, Lota Bhetta and Lugun Bhetta as legal heirs, where Sodho Bhetta died issueless. Similarly, Ghor Dhobi died leaving behind Jagdari Bhetta and Ghasi Dhobi died leaving behind his legal heir Ranjit Bhetta. It is further stated that Gulnath Bhetta and Sodho Bhetta, sons of Ram Dhobi, in order to meet legal necessities, sold and transferred 3 acres 75 decimals of land of ours, plot number 363 and the Khata number 76 to the plaintiff, appellant namely Srimati Chandramani Devi and Srimati Saroj Devi by way of registered security dated 5 to 1986 on payment of valuable consideration, and put the plaintiff appellant in class position of the same, which is hereinafter described in the suit. It is further stated that after purchase, the plaintiff appellant came in peaceful possession of the lands and have acquired perfect right, title, interest and possession of the land of area 3 acres 75 decimal being its rightful owner.
These are all the cause of action. Next para is the cause of action.
Yes,
Then what about the defendant?
Paragraph 4 minus. On the other hand, on receipt of summary notices, the defendant number 1 Ashok Bhagat filed his written statement through his power of attorney holder Ram Bhagat, stating therein that the suit as claimed is not maintainable and the plaintiff's suit is false, frivolous and vexatious, and as such is liable to be dismissed with compensatory cost. The plaintiff has got no cause of action to file the suit and the suit is barred by law of limitation and adverse position. The suit is also barred under section 34 of Specific Relief Act, and the same is also barred for non-jointer and misjointer of necessary part. As a matter of fact, the plaintiff has got no right, interest and position in any manner over suit property which exclusively belongs to the defendant. The defendant further submits that the land of Khata number so was recorded in the record of right as Kami Batai in the names of Ram Dhobi and Ghor Dhobi, sons of Chorkata Dhobi. The lands of Khata number so which stands recorded in the name of Ahilya who for realization of areas of land instituted a rent execution case suit number 468 of 1940-41 against Ram Dhobi and others, and the said suit is decreed in favor of Ahilya Kumar, and the execution of the said decree all the lands including so and so of the said village was auctioned, sold, and the same was purchased by Ahilya Kumar on 26/8/1944, and accordingly delivery of possession was given effect. So, whereas the auction purchase that was taken place, no document has been placed on record with respect to that. So, the defendants are claiming their title through Ahilya Kumar. They need to show that Ahilya Kumar was at least having the title to transfer the property, because nobody can transfer a better right than what they actually have.
That's
And both the courts below, only based upon the recital of the sale deed which was executed in favor of the defendant, has come to a finding that Ahilya Kumar had the title to transfer the property. Our
there is a
initial
presumption with respect to recitals also.
presumption cannot be with respect to contents of the document. Presumption will be with respect to genuineness of the document, especially when the contents of the document has been disputed by the other party. So these documents have never been brought up record. And this is further fortified from the fact that the M form was issued in my name. There was a rent fixation case 10 years after the
That's important.
And accordingly, delivery of possession was given to her through the process of court, and thereafter the said Ahilya Kumar, the landlord of the village and auction purchaser, became absolute owner of land of Khata number 76, and she remained in peaceful possession throughout till 14/12/1944, when she executed a registered sale deed being deed number 641 dated 14/12/1944 for consideration and transfer of the lands of Khata number 76, including the land measuring an area 3.75 acres in plot number 363. Which is the suit land in favor of Ashwin Kumar Bhagat, defendant number 1, and possession was conferred to defendant number 1. And thereafter, this defendant has still been coming in until uninterrupted possession of the suit lands.
Let us see the issues. One is section 34. Other
Paragraph
is
number 8.
limitation. And 6. 5 and 6 would be sufficient. Limitation has also been decided.
Yes,
It has been decided in your favor.
no against.
Let's see the finding.
Paragraph number 14.
Now the main point. Right?
Yes.
Where is the decision on limitation? If the limitation is against you, the matter ends full stop to that. Where is the point of the limitation?
Limitation, the appellate court has not dealt with limitation. It was the trial court has also decided issue of limitation. The appellate court has also only dismissed it on the ground that the registered deed that was filed by me was a certified copy and not a registered, which is at paragraph number 18. 19.
You are supposed to produce the original sale deed. Why did you produce it?
It was not in possession of the paper. But certified copy is also now a public document as per the recent judgments of the Supreme Court. Because it is a public record of a public document.
Was the execution of sale deed in your favor under challenge?
No, it's not.
It was not under challenge. The competence was under challenge.
Yes.
Read para 14.
Para 19 is the finding, that's para 14 is again if the arguments have been reversed.
No, para 14 has lots of findings also. Read para 14.
Now the main point for determination and adjudication of which this appellate court has to consider whether plaintiff appellant on the basis of registered sale deed dated 5 to 1986 have acquired right, title, interest and possession of the suit land or not, and whether the plaintiff's suit is hopelessly barred by limitation and adverse possession. As per the case of the plaintiff appellants, they have purchased the suit land from the legal heirs of the recorded tenant in the year 1986 on payment of valuable consideration, and from the very date of purchase, the acquired right, title and interest and possession over was also conferred on the very date of registry. But on perusal of record, it appears that original registered sale deed dated 5 to 1986 has not been submitted and filed in this case by the plaintiff appellant. And on perusal of Exhibit 4, it appears that at the time of execution of alleged sale deed dated 5 to 1986, the consideration amount was not paid to vendor Udnat Bata, and since he was an illiterate person, and therefore instead of transferring of 1 acre land, it was manipulated to be 3.75 acre under plot number 363, Khata number 76, and later the vendor, Budnath Beta, due to non-payment of consideration amount, cancelled the alleged sale deed through registered deed and did not hand over the possession of any land under plot number 363. On perusal of record, it further transpires that after purchase from Budnath Beta and others, the plaintiff applicants were never acknowledged as tenant of suit land area 3.75 acre, and therefore registered 2 was also not prepared in their name, and no rent receipt was ever granted by Anchal office for an area of 3.75 acre in favor of plaintiff applicant. There was no explanation on the part of the plaintiff applicant why its vendor Budnath Beta raised objection before registry office when he had himself executed the sale deed dated 5/2/1986, and why rent receipt was not issued in favor of the plaintiff applicant even after purchase of the suit land of area 3.75 acres. There is no proof of any document regarding possession of the plaintiff's applicant over the suit land, and applicant has not been able to file the document whether they, after purchase of the suit land, filed any petition for mutation of their names at the Anchal office. Since there is no original sale deed lies in favor of the plaintiff applicant with respect to the suit land, that their names has not been mutated at the Anchal office, no reason whatsoever was assigned in the plaint, and the entire pleading of the plaintiff applicants is silent on this point, that whether any valid title was passed in their favor on the very date of execution of sale deed in the year 1986. The answer would be negative because of the fact that after execution of the sale deed, the vendor, as per his case, she was not paid any consideration amount, and false assurance was given that the consideration amount to be paid at his residence, and when no consideration amount was paid despite assurance given, the vendor of the plaintiff got the sale deed cancelled at the registry office, which will appear on perusal of the document Exhibit 4 filed by the plaintiff applicant itself. It goes to show that no valid.
That is enough.
But,
That is enough.
but this cancellation cannot be valid, Manas, because once a deed has been executed and title has passed, it can
No,
only
it
be.
doesn't. You see, passing of title is very technical. Passing of title is very technical. If no consideration amount is mentioned in the sale deed, and if it does not even mention about future payment, and if it mentions about future payment and not paid, then also the deed is absolutely void. This is the finding of the court.
So that finding could not have been arrived at. First of all, because this was not the case of defendant. Secondly, on this grounds, registered sale deed cannot be cancelled. And the court cannot rely upon a cancellation deed. Cancellation deed has no legal effect. If a registered deed has to be cancelled, it has to be cancelled in accordance with section 31 and 34 of
It's
the
not that the deed cannot be cancelled ever.
It can only be cancelled by a competent civil court, not by a cancellation.
That is not the only mode. At times the deed can be cancelled by the registrar also. Maybe the jointly they had filed a petition for cancellation.
It cannot be, because there's now the Supreme Court has settled the issue. It's in Satyapal that a registrar cannot cancel, or any quasi-judicial authority for that matter cannot cancel a registered sale deed. So this cancellation has no legal effect. Therefore, the court has tried to make out a third case which was not even pleaded.
It was not the case of the defendant that the sale deed was cancelled.
No rights.
Then by who has put in these exhibits?
Yes.
You yourself has put in these exhibits?
Yes. This was put by. So the court has relied upon my exhibit, and the court is also saying that on perusal of the document, there seems to be a cancellation, if at all a cancellation deed. But
So,
by way
according to
of,
the court, you are failed to make out your own case. You are the plaintiff. As per the court, you have not been able to satisfy the court with regard to your own case, irrespective of the plea of the defendant.
because the courts did not made a substantial error of law in view of the fact that my certified copy of the registered sale deed has not been relied upon.
What happened to your sale deed? Non-production of your original sale deed has a lot of bearing in this case. You cannot ignore that.
That was not in possession of the defendant, but the certified copy was filed.
Non-possession of your registered sale deed has a lot of bearing in this case. There is no explanation as to why you did not produce the sale deed. Did you give an explanation that it has been lost? No.
This is one judgment which will also be similar.
Which paragraph?
Paragraph 22 and 22 minutes.
Yes.
Section 74 deals with documents which are public documents. Subsection 2 thereof makes public record kept in any state of private documents within the purview of public document under Section 74. Going by Section 75, certified copies of public documents shall be given on demand by public officer having the custody of public document, together with a certified copy written at the foot of such copy that it is a true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title. Such copies so certified shall be called certified copies in terms of Section 76. It is to be noted that in the case on hand, a certified copy of Exhibit A series dated 27/8/1928 was produced by the applicant. As noted earlier, the courts below found that it is registered with the sub-registrar's office. The contention of respondent is that it is only a certified copy and not the original document. In the light of the aforementioned provisions under the Evidence Act, there can be no doubt with respect to the permissibility for the production of such a certified copy as secondary evidence in law in regard to the existence, condition or contents of a document. As per Section 77 of the Evidence Act, such certified copies may be produced in proof of the contents of the.
So it can be produced in evidence in regard to its existence, condition, and content.
Yes.
All three.
So contents of the original document can be proved by certified copy.
Let's proceed further. As per Section 77.
As per Section 77 of the Evidence Act, such certified copies may be produced in proof of contents of the public documents concerned. Section 79 deals with presumption as to genuineness of certified copies. Now, if you lordship may kindly come to para 34.
Yes. Para
Para 30 minutes.
31.
30. Having regard to all the aforesaid facts and in the light of the various provisions of the Evidence Act mentioned herein above, we will firstly consider the question whether the applicant plaintiff has succeeded in proving the contents of Exhibit A. Going by Section 65E, when the original of a document is a public document within the meaning of Section 74, secondary evidence relating its original is as to its existence, condition, or contents may be given by producing its certified copy. Exhibit A1 indisputably is the certified copy of a sale deed number so and so. In terms of Section 74(2) of the Evidence Act, its original falls within the definition of public document, and there is no case that it is not certified in the manner provided under the Evidence Act. As noticed here and above, the sole objection is that what was produced as Exhibit A is only a certified copy of the sale deed, and its original was not produced in evidence. The hollowness and unsustainability of the said objection will be revealed on application of the relevant provisions under the Evidence Act and the Registration Act 1908. It is in this regard that Section 77 and 79 of the Evidence Act, as extracted earlier, assume relevance. Section 77 provides for the production of certified copy of a public document as secondary evidence in proof of contents of its original. Section 79 is the provision for presumption as to the genuineness of certified copies. Genuineness of certified copies provided the existence of law declaring certified copy of a document of such nature to be admissible as evidence. When that be the position of such nature to be admissible, when that be the position under the proceed provisions, taking note of the fact that the document in question is a registered CLD, falling within the definition of a public document, the question is whether there exists any law declaring such certified copy of a document as admissible in evidence for the purpose of proving the contents of its original document. Subsection 5 of Section 57 of the Registration Act is the relevant provision that provides the certified copy given under Section 57 of the Registration Act shall be admissible for the purpose of proving the contents of its original document. In this context, it is to be noted that certified copy issued thereunder is not a copy of the original document, but it is a copy of the registration entry, which is itself a copy of the original and is a public document under Section 74(2) of the Evidence Act, and subsection 5 thereof makes it admissible in evidence for proving the contents of the original. There is no case that foundation for letting secondary evidence was not laid, and as noted earlier, both the trial court and first appellate court found it admissible in evidence. So if my certified copy would have been taken into consideration, my the outcome of the case could have been different. Therefore, both the courts below have made a substantial error.
Or the learned counsel appearing on behalf of the appellant. This appeal has been filed against a judgment dated 29/9/2018 in bracket. Decree dated 12/10/2018 passed in civil appeal number 1 of 2018 by the learned principal district judge Kutti, whereby the appeal has been dismissed and the judgment dated 21/11/2017 within bracket decree dated 1/12/2017 bracket close passed by the civil judge senior division first Kutti in original suit number 5 of 2011 has been dismissed. The learned counsel for the appellant has submitted that the plaintiff has lost in both the courts, but a substantial question of law arises for consideration in this case. The learned counsel has submitted that the plaintiff is claiming the property by virtue of registered sale deed dated 5/2/1986 from the legal years of the recorded tenant. And at the time of filing of the Bidari return and assessment of rent in assessment case number 51 of 1955-56 and form N, the recorded tenant were found in possession of the property and rent was assessed in their name, who continued in possession and sold the property to the plaintiff by delivery and also delivered possession by virtue of registered sale deed dated 5/2/1986. The learned counsel finds that the defendant were claiming the property by virtue of auction sale which had taken place way back in the year 1944,
Yes.
in the year 1940, no, in the year 1941, and they are the purchasers of the property by virtue of registered sale deed executed by the auction purchaser of the property. The registered sale deed is dated 14/12/1940. He submits that it is not in dispute that the registered sale deed dated 5/2/1986 of the plaintiff and the registered sale deed dated 14/12/1944 of the defendant were in relation to the same property. Correct?
Yes, ma'am.
The learned counsel has referred to the findings of the learned first appellate court, which is concurrent finding
Yes.
that adverse inference has been drawn against the plaintiff on account of non-production of the original sale deed. As the plaintiff had produced only a certified copy of registered sale deed dated 5/2/1986. The learned counsel has referred to the judgment passed by Honorable Supreme Court reported in 2023 SCC Online SC 1183 within bracket Appaya versus Adimuthu, decided on 20th of September 2023 and has referred to paragraph 30 of the same judgment to submit that as per section 65E of the Evidence Act, when the original of the document is a public document within the meaning of section 74, secondary evidence relating to original, that is as to its existence, condition or content, may be given by producing its certified copy. The learned counsel submits that it has been held by referring to section 77 and 79 of the Evidence Act that section 77 provides for production of certified copy of a public document as secondary evidence in proof of contents of its original, and section 79 is the provision for presumption as to its genuineness of certified copies, provided the existence of a law declaring certified copies of a document of such nature to be admissible as evidence. He submits that the provision of section 57(5) of the Registration Act has also been taken into consideration, where it provides that certified copy given under section 57 of the Registration Act shall be admissible for the purpose of proving the contents of its original document. And it has also been held that the certified copy issued thereunder is not a copy of the original document, but it is a copy of the registration entry, which is itself a copy of the original and is a public document under section 74 with bracket 2 of the Evidence Act and subsection 5 of section 57 makes it admissible in evidence for proving the contents of the original. The learned counsel submits that non-production of original sale deed dated 5/2/1986 was not fatal to the case. Rather, the same was admissible in evidence, and the learned courts have misdirected themselves by taking adverse inference on account of non-production of original sale deed dated 5/2/1986. That's all.
Yes.
Arguments concluded. कल लिखेंगे. The orders से time.
Regarding cancellation of registered deed, your lordship, the ladyship has already held that registered deed cannot be cancelled by a constitutional authority. In a WPC, Preeti, there's also a Supreme Court judgment as well.
The learned counsel has also submitted that reliance has also been placed on the deed of cancellation, and he submits that a registered document cannot be cancelled. It can only be cancelled by the registration office by executing a deed of cancellation. It can only be annulled through a competent court of civil jurisdiction. Post-mortem. इनको तो टाइप करने में भी टाइम लगेगा परसों.
From supplementary list for order we defeat item 3, second appeal. Item 3, second appeal 208 of 2015.
Defective.
Two surviving defects are there, ladyship, for which an IA has already been filed. IA number 8081 of 2019. The defects are regarding the name of applicant number 4. Manoj Saw.
What happened to Manoj Saw?
The defects are regarding the name of Manoj Saw, Manoj Kumar Saw, for which IA number 8081 of 2019 has been filed, stating that Manoj Saw and Manoj Kumar Saw are the
Alias
same.
name we will not permit.
We have,
If alias name is not there in the record, we will not permit alias name.
in the IA we have stated that
We don't bother about it. You see, it's not a criminal case where somebody else is putting your name.
that is
If
the
you are a party to the proceeding, you have to object to your name also. We will not permit it. You have to make this correction. We are not going to permit it. Manoj is a very common name. We do not know who is going to stand in place of the actual person.
ladyship, we have annexed the Aadhaar card also.
Aadhaar card is not a document of identity.
The main
It is based on self-declaration. We will not acknowledge it. And we will not ignore this.
may I pray for 1 week's time and see
What instruction is? If you are filed an IA, I reject it.
checking the records of the
We are not going to permit alias names. We will not permit alias names. Will you contest this one?
yes, it's concurrency the plaintiffs, appellants, and declaration of right.
You are the plaintiff.
Yes, plaintiffs, appellant.
You get hold of the certified copy of the Wakala form. Simple. We'll see that. How have you signed? We'll not change your name. But we will not change your name under any circumstances. They don't have the certified copy of Wakala. We will not permit this. No? Tell us.
Praying for some time, ladyship.
Sometime for what? I will reject this idea. I will reject it. I will not permit this.
There is one more idea regarding the substitution of appellant number 1.
There was a preemptive order.
Yes,
We filed an idea.
we had filed an
Yes, we have filed an idea. Preemptive order has taken its effect.
that is why it was dismissed and thereafter restored.
Sorry?
Well, the peremptory order was in force for removing the defects, after which an IA was
After
filed.
that, it was restored.
Yes, after that it was restored.
SA number 208 of 2015. IA number 8081 of 2019. The Council for the Appellant has submitted that this interrogatory application has been filed for recalling and modifying the previous peremptory order dated 13/2019 and for ignoring the defect in connection with name of
Appellant number 4.
Appellant number 4. He submits that Appellant number 4 has been named as Manoj Kumar Sao, whereas in the judgment and decree the name of the Appellant number 4 is Manoj Sao.
Manoj Sao.
Appellant number 4 was the plaintiff,
Yes.
was the plaintiff before the court. He submits that Manoj Kumar Sao and Manoj Sao are one and the same person. And in support of that, Aadhaar card has been annexed.
Annexure IA/2.
Considering the fact that the plaintiff, that Manoj Kumar Sao was one of the plaintiff in the case. Manoj Sao was one of the plaintiff in the case in which he disclosed his name as Manoj Sao and not Manoj Kumar Sao. And the judgments have been passed by the name retaining as Manoj Sao. This court is of the view that interrogatory application number accordingly IA number 8081 seeking to ignore the defect in connection with name of appellant number 4 and his wakalatnama is hereby rejected. The council is granted. How much time do you need to remove this? Or you want to challenge this order? You give your own declaration. अपना नाम नहीं कुमार घुसा दिया. इसका क्या मतलब?
Leadership
Huh? What is this?
in the Aadhaar card it was
Aadhaar card, I don't think so.
that is a self-declaration.
अपना नाम में कभी कुमार, कभी किशोर, कुछ भी घुसा दीजिए. It's such a common name in state of Jharkhand. बताइए क्या करना है अपन. Is there any other IA with defect?
Regarding not regarding defective leadership, one more IA is there for substitution of diseased appellant number 1. IA number 1939 of 2021.
First we remove this defect. There are other defects.
There are two defects in leadership. The two surviving defects both were written in the name of appellant number 4.
Okay.
Manoj.
The council submits that both the defects, surviving defects are in relation to appellant number 4, which are defect 1 and defect 2. Time till 6th of January.
May I pray for
Calendar
some?
week.
May I pray for some more time?
Time till 16 January is granted to the appellant to remove the surviving defect. Ready. चलिए. ये नाम का एरर होता है ना, वकालतनामा से टैली करा देना, मैं आपको बता रहा हूँ. Be very careful. Plaintiff का वकालतनामा है ना, we'll send it for handwriting expert. It's something very serious. Criminal case में चलता है AES नहीं, civil में नहीं चलता है AES नहीं. Anybody else will stand for the property. be very, very sure about what your client is saying and better meet him also. Get the certified copy of the Wakalatnama also.
Item 4, second appeal 610 of 2016.
Yes, please.
I would kindly see. So far, the defect number 4 is concerned, Your Lordship. If Your Lordship see the SR report, Your Lordship, the name of the father of the applicant number 4 had already been given. So far as correction in the degree is concerned, Your Lordship, there is certain later dated, Your Lordship, 11/9/2018 of the learned court below, Your Lordship.
What does it say?
My Lord, they are saying that two appeals were filed, etc., Your Lordship, and as such, on the basis of this, that may be treated. They have not made any correction in degree, Your Lordship, which was sent back to the learned court below. I think, Your Lordship, that should be again sent back for correction, Your Lordship. Whatever he has written in his note, that is to be recorded on the degree, Your Lordship.
They say that two appeals were filed against the same judgment. One was
Same.
a cross appeal.
A
The
one-
valuation was different.
Valuation was different.
Yes. So there has to be a difference. Why should it be sent back?
As Your Lordship think it, Your Lordship. That is Your Lordship. Then Your Lordship, the defect number 5 may be ignored.
What
Your
is
Lordship.
this?
4 and 5 can be ignored, and 2 I will remove, Your Lordship. Suit value, appeal value, and second appeal value.
SC number 610
4 and 5
2016.
can be.
एक तो आप पेरेंटेज में भी तो फर्क है. Defect number 4. The learned counsel submits that with respect to defect number 4, the certified copy was sent for correction. With respect to defect number 2 and 5, the certified copy was sent for correction.
No, 4 and 5.
4 and 5.
2 I will remove. Your Lordship.
Yes, the certified copy was sent for correction. And a report has been received from the concerned court. From the perusal, with respect to defect number 4, the perusal of the letter number 179 dated 11/9/2018 revealed that the parentage of appeal number 2 has neither been mentioned in the plain memo of appeal or the judgment and decree passed by both the courts. And father's name of appeal number 2 as Dr. Ajit Kumar Sinha is not mentioned. तो आप उसको करेक्शन करना पड़ेगा.
उस दे दिया गया. That has been reported in the order, Your Lordship. ऐसा रिपोर्ट में किया हुआ है. That has been given, Your Lordship. Name of the father of the applicant number 2.
Appeal number 4.
Applicant number 2.
Appeal number 2. आप इसमें नहीं डाल सकते ना. You were the plaintiff or the defendant?
My Lord, I was plaintiff, Your Lordship.
You were plaintiff.
My
You have not disclosed your father's name in the plaint. ना plaint में है, ना written statement में है, ना appeal में है, कहीं नहीं. यहाँ पे कैसे? The counsel for the appellant is directed to make necessary correction in the cause title in terms of the judgment, the description of appellant number 2 in the judgment and the decree. Judgment and the decree. So far as the defect number 5 is concerned, it relates to suit and appeal value given in the certified copy of the decree. In that connection, in view of the explanation given by the learned court in letter number 176 dated 11/9/2018, the defect is ignored for the present.
And I will have to remove the defect number 2 also, Your Honor.
Certainly. The counsel for the appellant is permitted to remove the defect in connection with defect number 2 and 4 by 16th of January 20.
Obliged.
If the defects are removed within time, post on 22nd. And appropriate.
Item 5, second appeal 151 of 2020.
Yes, ma'am.
Objections made. I think some minor corrections are made.
They are partly removed the defects. Right, the same record. Essay number 151 of 2020. Counsel for the appellant is permitted to remove the surviving defects by 16th of January 2026 20. If the defects are removed within time, post on 22nd.
Item 6, second appeal 167 of 2023.
There are 4 defects. I will come to cure the defect.
Same order.
One more thing you will wish.
इसके लिखते हुए ना or to file an appropriate application in connection with one or the other. ये ना सब में लिखा है. कभी कोई प्रॉब्लम हो काउंसिल प्लीज.
इसमें ये कैलकुलेशन ऑफ लिमिटेशन इज रॉन्ग इन द बैक ऑफ द वकालत.
तो आप जानते हैं about the limitation that you should fight in. You are an learned advocate.
Here, you guys.
Orders item 7, second appeal 374 of 2005.
Yes,
Case, madam, petitioner filed an interrogatory application for substitution of legal heir of respondents. B8 and 9.
Is this an admitted appeal?
My lord. Earlier, my lord, number 10013 your lordship and some.
It's a very
due to
important
inadvert-
question of law.
My lord.
It's a very important question of law. आपको पता है क्या question of law है?
My lord.
बताइए.
Whether in view of finding the appellate court below that court of wards ended on so and so exhibit 3 issued on 25/4/2000 by the manager Ramgarh State could be accepted as a valid.
That's right. हाँ बताइए क्या कौन बन गया?
Substitution हो जो रही है
किसका
फाइल किए थे but due to inadvertence
Whose substitution?
respondent number 6 B8 and 9 my lord. But due to inadvertence my lord we have wrongly written by interlocutory application which are filed your lordship. Then thereafter on last
IA number क्या है?
lordship directive.
IA number
IA number your lordship 10013 public 2025.
उसके बाद आप क्या किए?
Thereafter my lord, as per direction your lordship, we have filed another IA. Another IA your lordship,
Necessary correction.
necessary correction your lordship. वो जादव के जगह पर भी मातो के जगह पर जादव हो गया।
Who has expired? Respond number 6,
6B, 8 and 9.
6B, 8 and 9. लिखिए IA number 16654 of 25 has been filed seeking amendment of IA number 10013 of 2025, which in turn was filed for substitution of क्या problem? So the problem? Which was filed for substitution of respond number 6B, 9 and 8. The learned counsel submits that in the IA number 10013 of 25, due to an inadvertence, the names have been wrongly mentioned.
And designation also.
Designation?
Designation respondent number 6B, 8 and 9 होना चाहिए था। हम लिख दिए थे 8, 10 and 17.
8, 10 and?
17. Earlier.
No, respond number 9, 17 and 8.
Yes, yes.
He also submits that the respondent numbers have also been wrongly mentioned as respondent number 9, 17 and 18 in IA number 10013 of 25. The learned counsel submits that the prayer for amendment of IA number 10013 of 25 be allowed. Any objection, madam? No. The learned counsel for the respondent has no serious objection so far as prayer for amendment is concerned. After hearing the counsel for the parties, IA number 16654 of 2025 seeking to amend IA number 10013 of 2025 is allowed. The counsel for the applicant is directed to carry out the necessary amendments in IA number 10013 of 2025 during the course of the day. अब देखिए IA number 10013 of 2025. Issue notice to the proposed legal year
2, 3.
and successor of respond number 6B,
I have stated in para 2, 3.
6B, 9 and 6B, comma 9 and 8. Namely, Naresh Mehto, Keshav Mehto, and Gona Mehto, for which requisites be filed by 6th of January. Hold this case through speed post कहाँ के लोग हैं? चतरा के. Through speed post and ordinary process. Pose this case on 23rd of February.
Had to meet second appeal 147 of 2008.
Orders in full available. Why is it listed for orders? Three to 16 for valid. Respond number 1 to 1718. इसका registration order है.
कॉस्ट नहीं पाएंगे
कॉस्ट नहीं जमा
एक्चुअली सेकेंड अप्रैल में कॉस्ट हुआ था सीएमपी में ऑर्डर रेस्टोरेशन तो हो गया लेकिन ये फाइल नहीं किया है
सीएमपी का कॉस्ट इसका
सीएमपी में से कुछ है नहीं
सीएमपी में सब सेकंड अपील में
Second appeal number 147 of 2008. This appeal has been restored pursuant to order passed in CMP number 119 of 2023. And as per office note, the cost of rupees 1,000 has not been deposited. Time till 6th of January 26 is granted to the appellant to deposit the cost. Failing this, this appeal shall stand dismissed without further reference to bench. On is the appeal. Since the appellant is absent, let a soft copy of this order be communicated to the appellant for compliance.
Item 9, second appeal 429 of 2015.
Please.
Limitation petition, my lord. 18 days delay.
I hear you on minute. Your notice was issued on limitation?
No, the other side is already appeared. Copy has been served on DVC. I am actually not having a copy towards me.
You are appeared, no? 18 days delay, you are proposing. I number 11553 of 2022 in essay number 429 of 2015. The counsel for the appellant has submitted that the appeal is barred by limitation by delay of 18 days. The petition seeking condemnation of delay be allowed. He has referred to paragraph number
4 and 5.
Paragraph 4 and 5. The learned counsel for the respondents. Only one respondent?
Yes, we are doing this. DVC is that's all.
Respondents has no serious objection so far as prayer for condemnation of delay is concerned. Considering the submissions and having gone through the interlocutory application seeking condemnation of delay, IA number 11553 of 2022 is hereby allowed. Post this case and appropriate hearing on Friday in the supplementary process to be taken up as first case. First in. This is not the mentioned time, ma'am.
Hearing matter was fixed by bench slip and due to possibility and it was not there.
I'm not as fast as you are. I'm a slow judge.
No, they should just train.
You are mentioning it at the time of rising. You should have mentioned it at 10:30. Right? I'm not as fast as you are. Don't assume your speed, don't try to match it. I'm a very slow judge. There is all likelihood that even the second item may not be taken up if it is a long